Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Zul Iman bin Uzair, matrix number 280092. Today, for my part, I will be presenting about the introduction for our group case review. So, to begin with, I will be answering the question of what is misrepresentation. The general definition of misrepresentation is a relation between two parties subsisting between the parties that one of the parties gives an untrue statement of fact or law which to persuade another party to enter a contract with him, resulting in an unfair advantage over the party involved. Next, the concept of misrepresentation as applied by the common law can be seen in the case of Sdn Realty Sdn Bhd versus Teh Kim Dar dated in 2003, where the court stated that the definition of misrepresentations contains three distinct elements, in which are: the first one, the representation must be unambiguous. Secondly, the representation must be directed to the party that has been deceived. And lastly, the representation induced the contract materially. However, in Malaysia, the law regarding misrepresentation is provided under Section 18 of the Contract Act 1950. Section 18, subsection A distinguishes misrepresentation as the positive statement in a way that it is not justified by the information given by the individual making it, which is false, even though he considers it to be true. Furthermore, subsection B illustrates that any breach of duty, whether it is without any intent to deceive, gives the individuals who are committing it an advantage by misleading another. I think that will be all from me. I'll pass it to the next presenter. Thank you.
In the case of Low Kon Fatt against Port Klang Golf Resort, the defendant, the Port Klang Golf Resort, had advertised an advertisement in the New Straits Times, and the plaintiff, a businessman residing in the Peninsula Selangor, had read the advertisement. He later was interested in the package stated in the advertisement and called the defendant's office. The defendant had later handed pamphlets and brochures glorifying the resort and boasted about having three-story golf resort complex equipped with convention halls, a health center, sauna, gymnasium, squash courts, snooker and games room, a library, pro shops, boutique, hair salon and restaurant, floating chalet, a floating restaurant and marina for yachts and boats, and an 18-hole championship golf course. Furthermore, the defendant trumpeted the resort in the brochure with a picture of sleek, white-colored yachts and boats mooring alongside the jetty, fringed with coconut palms and shady trees fronting the sea, with more extolling message. The plaintiff claimed that he was lured by the brochure given by the defendant, which promised the said facilities. The plaintiff then signed a license agreement dated on 20th April 1991 with the defendant and subscribed for 320 Class B shares of 100 ringgit each. The total amount paid by the plaintiff was 32,000 ringgit Malaysia. He had also acquired a membership to the resort with the payment of 60 ringgit per month to use the facilities provided. On the same day, the plaintiff signed another license agreement with Rice Park Corps Sdn Bhd for the use and enjoyment of the facilities. However, the plaintiff was dissatisfied with the facilities provided by the golf resort, as there were only 9-hole golf course, a single-story clubhouse, 2 tennis courts, a few wooden chalets, and a swimming pool instead of the facilities promised in the brochure. The plaintiff then confronted the manager and sent a formal notice for a rescission of the agreement and refund of the sum paid, including prayers for damages and interest at 8%, including costs.
Next, we move to the issues for the case. The defendant described his resort in pamphlet as a seaside golf resort which provides facilities such as 3-story golf resort complex equipped with convention halls, a health center, sauna, gymnasium, squash courts, snooker and games room, hair salon and restaurant, floating chalet, a marina for yacht and boat, 18-hole championship golf course, and many more. So, the first issue here is whether this representation induced the plaintiff to enter into the contract with the defendant or not. However, it turned out that these facilities mentioned had never existed yet when the plaintiff arrived. So, the second issue here is whether puffing or exaggeration in advertising material with the intent and result of inducing the representee to enter into a contract constitute a representation or not. Next, the defendant told the plaintiff that they will provide the said facilities, but after they request approval from the Port Klang authority in the future. So, the third issue here is whether this is still a case of misrepresentation under Section 18, Paragraph A and B of the Contracts Act 1950 or not. Moving on. The defendant put an exclusion clause on the last page of the brochure that stated that the contents and information contained herein do not constitute or shall be deemed to constitute any warranty or representation of whatsoever nature, whether expressed or implied, on the part of Port Klang Golf Resort Management Sdn Bhd and its associates, and are subject to changes without notice at the absolute discretion of Port Klang Golf Resort Management Sdn Bhd from time to time. So, the fourth issue here is whether the clause attempts to exclude the defendant's liability that goes to the root of the contract or not. In the same context, the fifth issue will be whether such exemption clauses could be relied on by the defendant or not. Lastly, after all of the things happen, the sixth issue for the case will be whether the plaintiff can claim for the rescission for the misrepresentation made by the defendant or not.
Assalamualaikum. My name is Nurulwaiti Siti Fazil and my matric number is 280316. Today, I will be presenting about arguments by parties in the case of Low Kon Fatt against Port Klang Golf Resort Sdn Bhd. Next, as for the plaintiff claimed that he signed up for the resort membership because he was persuaded by the brochure which promised various high standard facilities at the resort. However, he was dissatisfied with the facility provided as it does not comply with the brochure at all. Then, he was informed by the general manager, Jafri Abangwate, that the facility promised will be made available in the future. The defendant also admitted that they had recklessly and without regard of the implication, published the aforementioned brochure first without consulting with the Port Klang authority. Then, the plaintiff sought to have the agreement rescinded and for the reimbursement of the consideration paid. Next, as for the defendant argued that he significantly relies on the exclusion clause to claim that none of the assertion made or included in the brochure constitute a guarantee or representation of any kind, and the license agreement between the defendant and the plaintiff will only involve golfing facility. Then, the defendant also asserts that he has an intention to provide and they will supply the facility in the future, but they have failed to establish that the facility will be made available in the future because they did not get an approval from the Port Klang authority due to the fact that they will endanger shipping in the area. That's all for me. Thank you.
Assalamualaikum. My name is Assoffat binti Anwar, matrix number 280902, and I will be presenting about the decisions of the court in the case Low Kon Fatt against Port Klang Golf Resort Sdn Bhd 1998. So, after the question and answer in the cross-examination session was conducted, the High Court Judge Kamalanathan Ratnam Judge had commented that the provided testimony by the defendant explicitly reveals that the defendant's intention to include the services mentioned in the brochure. However, communication between the claimant and the Port Klang authority clearly indicates that no permit would be given for the planned sea sports facilities because they would endanger the shipments in the region. The plaintiff was also induced into entering and signing the contract. The contractual term in the brochure was acknowledged to hold the provided facilities in the future. However, it is very transparent that the statement of intention was involved representation. Even such a fact cannot be accurate because if the defendant had simply inquired the Port Klang authority prior to publicizing the brochure, the defendant may determine that any such representation of the availability of sea sport facilities could not be true. The Learned High Court judge stated that it was the defendant that had neglected the consequences of producing the brochure without ever checking with Port Klang authority, and that the general manager had the duty to oblige. And the section 18A and B of the 1950s Act is to be applied. Next, as for the defendant's case on the effect of the exclusion clause, however, was rejected. The exclusion clause provided by the defendant could not be used as a security or a defense, as the subjected sea sports facilities was the reason for the plaintiff to enter into the contract in the first place, and the defendant failed to provide the contracted promised facilities. All in all, it is therefore decided by the High Court judge that the plaintiff was approved of the rescission and a refund of 32,000 ringgit Malaysia and the cost, but however, no interest such that the plaintiff had enjoyed the golfing facilities anyways. That is all from me. Thank you very much.
Assalamualaikum warahmatullahi ta'ala wabarakatuh, and greetings to lecturer and friends. My name is Assoffat bin Razali, and I will be presenting about the conclusion for our case review today. From the detailed discussion that we have made, it can be seen that the case of Low Kon Fatt against Port Klang Golf Resort Sdn Bhd had illustrated the concept of misrepresentation in the Malaysian contract laws and became a clear case to illustrate Section 18A and 18B of the Contracts Act 1950. In the case, misrepresentation had occurred when the defendant gave the plaintiff a brochure about the resort before entering the agreement. The brochure had contained the pictures and statement that showcases the many facilities that will be provided in the resort. Among them includes a marina, floating seafood restaurants, and chalets. Various sea activities are also available. This had influenced the plaintiff into entering the agreement. However, the plaintiff later found out that most of the amenities were nowhere to be found and later brought an action to court requesting for rescission of contract. During judgment, the judge stated that a mere overstatement was not a representation, but if the representation had influenced the party to enter into the contract, therefore it is a representation. Additionally, although the statements are for the future development of the resort, it represents that there is intention to do so, thus making it a representation of fact. It was also proven that the brochure was intended for the purpose of influencing the plaintiff into the agreement. However, prior to making the brochure, the defendant did not seek counsel from the Port Klang authority regarding the project by the sea. This means that when producing the brochure, although intending it to be a form of influence, the defendant had no idea that the project was impossible due to safety constraints. They truly believe that the project can and will be done, thus having misrepresented the facts of the result. So, what can we learn from this case? Firstly, it is advisable for us to make sure that the object of any agreement does indeed exist before entering an agreement. This goes to both parties of a contract. As promisor, although believing such an object exists or will exist, must make sure that it is truly viable and can be erected or procured. For the promisee, on the other hand, the promise made by the promisor must be checked thoroughly. With the internet within our reach, it is quite easy for us to fact-check almost anything or even require services that can help us to determine whether there are such facts. Secondly, We should also remind ourselves that things that seem too good to be true are not necessarily what they seem to be, especially when it involves an agreement. A consideration towards an agreement should always be in balance between the two parties of a contract. Any more or less would come out as something too good to be true and will most often than not result in problems in the future. We must not let ourselves be influenced by such amazing offers before going through the terms of the agreement meticulously. Therefore, in conclusion, we should always be aware of agreements and their effects. That is all from me. Thank you.